because I feel like when we before she was going to try for child support, like I said, they told her she had to change the child's last name, and she didn't want to.
Enjoy the video, hit the like button.
Well, I'm sorry, at least custody and child support. I hadn't checked the visitation order yet. Anyway, the court did set up child support that started the first day of March 2026. Anyway, at this time, I asked the state for an open to tell the court what the state's requesting we do here today, how it deviates from if anything, from the original temporary order in this matter, and what the parties have requested and what you understand agreements and contests to be. Thank you.
Thank you, Your Honor. So the state is asking for a final order. We had that temporary order we did back in February, and so the state is asking to finalize. Um, state is asking to increase the current child support and cash medical. The current child support and the temporary order, Your Honor, is let me see.
I think it was 266.
Correct, Your Honor. 266, and then the cash medical was $39, and they both started March 1st, 2026. So he understands that his gross monthly income has increased. Before he was Mr. Harris was essentially working kind of like extra jobs and stuff until he could get his license to tow truck drive. So now he's got his license and he's doing his normal tow trucking. So his gross monthly income in that temporary order was $1,733.33. He now makes $600 a week, which comes out to being about $2,600 a month. So his current child support will increase to $433. Say we like that to start May 1st, 2026. We would also like the cash medical to increase to 104, Your Honor.
Give me that child support amount again, please.
Child support was 433.
433. Oh, thank you.
And then the cash medical is 104. And I took into account, just so you're aware, I took that into account that he has another child that he pays support for. He pays cash medical in his other case of 130, and like top maximum reasonable for cash medical for all of his children would be 9% that gross monthly income. So that'd be 234 max, 234 minus 130 gets you to the 104, and 4.5% of his gross monthly income is higher than that. So state's just sticking with the 104. State also is asking for the court to order retroactive child support. Total of $23,130, and that's including a $500 credit that Ms. Mercado said that he had given her money for school supplies. I believe Mr. Harris would say that he's given her other money over time, but I don't think he has any amounts known. I'll defer, Your Honor, the retroactive to you. But if I need to recalculate something, I can do so. And that timeline is from March 1st, 2022 through February 28th, 2026. So he understands the parties never lived together. And and current sports started March 1st, so 4 years back from the day before that is equal to that. As for non-disclosure, the temporary order said no non-disclosure. I haven't heard of any recent family violence issues between them. If I'm incorrect, then the court can do something different. But otherwise, they'd ask the court to continue the no non-disclosure. As for the issues the state does not have an interest in, it appears to the state that the parties are not having any trouble regarding the custody and visitation portions. Parties are joint main conservators with Miss Mercado as having the right to establish where Isabella lives, the child lives. No geographic restrictions on that. And the visitation is just standard possession order with the standard drop-offs at Miss Mercado's house. Um, so as they don't have any issues, I don't think they'll want anything to change to that. Um, I'd ask the court to apportion court costs, and state understands Mr. Harris is opposed to the at least the retroactive amount. Um, I think his main reason is that he feels that Mr. Mercado should have asked earlier. Uh, he alleges some things that happened. I don't know the truth of them, Your Honor. But um, I think in sum, his argument is that she should have asked earlier than today. Um, and I have a feeling he's also opposed to the current child support as well. Um, but we can hear more from his own words on that. I think his main issue is the retro. And for the retro, I've devised repayment for that. $166 per month, beginning May 1st, 2026. But Your Honor, as you know, state's pretty flexible on the repayment as well. So I think that's about it.
All right, then let's get some testimony from the parties and we'll see about what we're going to do on this one. All right,
Thank
at
you, Your
this
Honor.
time, Mr. Harris and Mr. Mercado, Mr. Mercado, you need to unmute yourselves and then need both of you to raise your right hands and let me get you under oath and we'll take it from there. All right, both raise your right hands, please. Do you both solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and that the truth will help you?
Yes, sir.
Mr. Harris, you so swear, sir?
Yes, sir.
All right, you're both officially under oath. I'm going to let the state call you both as witnesses. If there's anything either you think I need to know that didn't come out in your general testimony, you'll be allowed to testify that information with the court, so long as it's relevant to what we're doing here today, child support, visitation, that sort of thing. Anyway, I'm going to go ahead and let the state call you as witnesses. And then at the end of the hearing, if there's something you think I didn't hear that is relevant to me making a proper decision, I'll let you, both of you or either of you, bring that information up in the narrative so long as, again, it is relevant and admissible as in a court of law. Unfortunately, I got to hold you to the same standards as if you went to law school here in the state of Texas and passed the bar. So again, you got to follow the rules of civil procedure and the rules of evidence and all those other things that go along with it. But at this time, I'm gonna let the state call you as the witnesses and get what y'all in agreement about and what y'all not in agreement about. I will take judicial notice of the court file. We got a temporary order that's been in effect for a couple of months. The original order in this matter was filed back in July of last year. It shows service of citation on both of you last year. It looks like Mr. Harris in particular, he was also served in the month of July. And I will note for the record that the original petition in this matter did ask for retroactive child support. So this is something that, and regular child support. So this is something that's been on file and requested from day one. So at this time, I'll go ahead and let the state call your first witness, and we'll take it from there. Thank you.
Thank you, Your Honor. And I should let Your Honor know is that our temporary agree order, it said that the genetic test results were attached, but there was a mistake when it got filed. They weren't attached to it. Your Honor, it's already on file, and I can get a copy to you afterward, if you want to
Yep.
introduce into evidence, or you want me to do that. I apologize, Your Honor. It was just a error.
Okay, let's see. That's a temporary order. So a copy of the DNA test has already been filed with the court, and I'm going to take judicial notice of that file copy. And I've already noted that we found that Mr. Harris is the father based on that genetic testing, and it's way above the 99.99. So I don't need it. I'll note for the record that this is the original of the DNA test, and the one you filed was just a copy, and I'll accept the original for the purposes of the information concerning that. Mr. Harris is the father of the child that's before this court today, and it is above the 99.99 percentile, as we stated at the last hearing, and he is the biological father. You may proceed, then, Mr. Welch. Thank you.
Thank you, Your Honor. State calls Megan Mercado. What is your full name?
Megan Renee Mercado.
All right. And what is the full name of the child in this case?
December 12th of 2013.
And how old is she?
She's 12.
So, let's start with the easier part of this. The Do you recall the temporary order that we all signed back in February?
Yes, sir.
Now, are you asking the court to change anything regarding the custody, that you have custody of the children of no restriction on that, and that y'all are doing the standard possession order for visitation? Are you asking the court to keep that the same here?
That's perfectly fine with me. I don't think that he'll take advantage of it because he hasn't previously, but I have no problem with it how it is.
All right. And so, what health insurance does this?
She's through the state Medicaid here in the state of Texas.
Do you have access to private health insurance for us?
Sure.
All right. And hmm, are you asking for retroactive child support today?
Yes, sir.
And when did you and Mr. Harris no longer live in the same household together?
We've never lived together.
And has there been any issues of family violence between you two since since that temporary order?
Oh, no, sir.
Pass a witness.
All right, ma'am, I'll be back in just a moment. I'll let the state go ahead and call your next witness, please.
Thank you, Your Honor. State calls Alvin Harris. What is your full name?
Alvin Leroy Harris Jr.
All right. And just like with Miss Mercado, uh, do you recall that temporary order that we all signed back in February?
Yes, sir.
Do you have any issues with how it did the custody? Miss Mercado had custody of the child with no restriction on where she could live with the children. With y'all are just doing the standard visitation.
Yeah,
I
I don't have no problem.
All right. So what do you do for a living now?
Towing.
Towing. And
Tow.
how much do you make towing?
It like I said, it varies. It's 600. The base would be 600 because it's commission. So if it's busy, then I can make up to 600 or more. But if it's not busy, then it's probably the lowest I'll get would be 6 or 5. Yeah,
All right.
because it's commission.
And
So
that
I get
600 is that
30% of anything I make.
I get you, sir. And how often do you get that 600?
Like sometimes once a week, sometimes it's not 600 a week, sometimes it's 4 or 5. It just, like I said, it's not constant, but I say the
Let me
base
rephrase it. How often do you get paid?
weekly.
All right. So, before this $600 job, what were you doing?
I was doing side towing because my license was, my towing license, I should say, was suspended because
All right.
of
I get you. All right.
the past.
I get you. So, um, when did you start doing this side towing?
Like last year.
Do you remember the month? Is it near the end of the year, November, maybe?
It probably was like in November.
And let me see. And would you say that you made about 400 a week back during that side towing?
Yeah.
And so before November 2025, what did you do?
I would just do side jobs like cut grass, stuff like that. If they needed me for something, I would do it, whatever, just to
And,
make rent or whatever.
and when was your last above minimum wage job? When was that?
January 21st of 25.
All right. And how long had you worked at that job?
Almost 20 years, 15 to 20 years.
And
I
what
don't
were
know
you
the
doing?
exact.
What were you doing at that job?
Towing.
And how much did you make approximately at that job?
At that job, it was probably 950 after taxes.
And how often did you get paid then?
There weekly.
So, when did you and Miss Mercado no longer live in the same household together?
We've never lived together ever, like ever since before she was born or anything. We've never lived together.
All right. And so, um, from basically 2022 to today, how much cash or very expensive goods did you give to Miss Mercado for the benefit of than that 500 that we already discussed?
I wouldn't know. It wasn't never consistent, like always give her money or anything like that. It's just if she asked me for something and I had it, then I would. You know, most of the time it would be for like school or whatever, but or Christmas, but I didn't keep money. Like
All right, got it, sir.
anything I gave
Got it.
her, I didn't remember it.
So, do you have access to private health or dental insurance for?
No.
So, very briefly, sir, why are you opposed to the retroactive child support that I talked about in my opening speech?
Because I feel like when we before she was going to try for child support, like I said, they told her she had to change the child's last name, and she didn't want to, and so she couldn't get child support if she didn't change the last name. And then she waits all this time, and even when we'd have discussions, I'd be like, "Well, I'll try to pay you 150 a week if I can, if I had it at that time." And then she waited, and now they say she can't change, she doesn't have to change the last name, and now you're going to file. So you could have, because anytime we had a talk, and I'd be like, well, just file child support, but she didn't want to change the last name. So why would I have to pay way back then when you could have been on child support way back then? That's how I look at it. You could have been on child
Sir,
support, then you would
All
have
right,
had
sir.
to me a fight with that.
Okay, here's the problem, Mr. Harris. Under Texas law, this court and any court in the state of Texas is allowed to go back at least 4 years on retroactive child support on any child support case where there's a showing that monies were not paid or there was not an agreement and monies were paid based on that agreement. The court's allowed to go back at least 4 years and order retroactive back child support based on those prior 4 years, and go back even further if the person was trying to avoid paying child support. You know, you get those types every now and then. That's not this case. So I can go back to even past 4 years because under the law, this is your child. Under Texas law, you had a sexual relationship with the mother. You should, under that circumstance, you know, children can result. And the law is that you're obligated to pay them up to a minimum of 4 years back child support, sir. And it doesn't matter when she filed. If she filed it 8 years ago, you would have been ordered to pay 3 years back child support, but she filed it now. And so the court's allowed to look at 4 years. I know you're not a lawyer, but that's what the law is. So, so saying that she didn't do it or could have done it, that's not a factor, sir. The law is exact as far as that's concerned. She is allowed to go back a minimum of 4 years.
Even though I thought, like, I know that's my daughter, but you still didn't prove to me that that was my daughter until now.
That counts, sir. If you have a sexual relationship with someone, you know where babies come from, right? And now, and we have confirmed DNA analysis. I mean, your odds of this not being your daughter, you are over 300 plus billion to one. You'd win the lottery coming up this weekend. At least 50 times that this child's not yours. So, you know, it's about, I mean, 300 billion. There's only 10 billion on the whole planet. So we got to go outside this universe to start covering other folks there. So again, those are the
That
circumstances.
is okay.
All right,
But
but
that's
anyway,
the reason why I
if you
had
got
to,
information about monies that you did give other than the 500, I can count that. If you made a car payment for her or something along those lines, I can count that. If you bought the child a brand new bedroom suit, I'll count that. But if you just gave her $10 here, $15 here, that's not going to be enough to for the court to justify changing this more than the full and going back other than the amount over that 4-year time frame. But I'll let the state go ahead and ask you your next question, sir. Or if is there anything else you want to add why the court should not look at the required 4-year retroactive child support payment amounts there?
nothing.
I'm sorry, sir, I couldn't hear you.
No, sir.
All right. Anyway, I'll let the state ask you the next question. And again, at the end of the hearing, sir, if you want to make a closing statement, a closing argument, you can do that also. But the state can go ahead and ask the next question. Thank you.
Thank you, Your Honor. Have you had any issues of family violence between you and Mr. Mercado since we got our temporary order in February?
Never. Never know.
And how many children outside of this case do you have, biological or adopted?
2. I mean 1. I'm sorry, her and my son. That's it.
And this one other child, you pay support for?
Yeah.
Pass the witness, Your Honor.
All right. I'll be back to you in just a moment, sir. Any other witnesses at this time, Mr. Welch?
Actually, Your Honor, if I could just ask Mr. Harris how old that other child. I already know how old that other child is, but
Get it on the record, yes, sir.
Mr. Harris, how old is your other child? Not in this case.
12. He's 12.
All right. State's finish with questioning, Your Honor.
All right. So at this time, I want to start with you, ma'am, and then I'm going to go to you, sir. Is there anything else that you're asking for that the pleadings will cover that allow me to grant? And again, I know neither of you are lawyers, but is there anything else you're asking for at this time, ma'am, that I can grant based on the pleadings that are before the court this time?
The only thing I do have a question about, because he is non-active, is if I can apply for a conservatorship, sole conservatorship.
It's still, ma'am. No, you can apply for anything you like, but there's a burden of proof of getting from sole managing, from joint managing to sole. And if you look at what the differences you get to decide if your daughter wants to get married before the age of 18, you get that. If she wants to join the United States military, you get that. And if she has her any funds that she gets, say she becomes the next Disney star, you can manage that, and you get to manage the passport. But that's pretty much all you get for being a sole managing conservative versus a full joint managing conservative, ma'am. And that's and the burden of proof of getting there is different. Right now, the burden of proof in this case is by preponderance of the evidence. If you want to get something along those lines, you got to show clear and convincing. And it's probably not going to be worth your money on paying a lawyer to do it. All right. But yeah, that's left up to you. All right.
Okay.
I will let you know. People think they get that, they hear that word soul managing, and they think it's so much more, and it's not.
Well, it's not. I wasn't asking because I thought it was more that would benefit, you know what I mean, or anything like that. It's just solely based off of because he's a non-active parent.
Right. Yeah, ma'am. Yeah,
Why?
you can talk to your own counsel about what ramifications that has with it. I can't give you legal advice. There are certain things that can be brought up and things that could be were requested based on that. But for right now, that's not before the court. All right.
Okay. Yes, sir.
Anything else, ma'am?
No, sir. I don't think so.
All right, Mr. Harris, you have anything else you think I need to know, sir?
No, sir.
Okay. All right, then, Mr. Welch, anything else from the other parties? I'll let you go ahead and make a closing statement also. Thank you.
Your Honor, so essentially what the state's asking for is for the increase of the current child support to that number I told you earlier, $433 starting May 1st, 2026. the increase to the new cash medical of $104 starting May 1st, 2026. You heard testimony from Mr. Harris. He's now making 600 a week, approximately, maybe a bit more, but at least 600. And then I'd ask the court as well to order retroactive child support amount. Gave you that figure after that 500 deduction, $23,130 total. State's recommended repayment would be $166 per month beginning May 1st as well. And that was based off of the 6% interest plus 50, just so that it gets paid off. But Your Honor, if you want to make changes to that total, I won't object. And as for the things that the state's not really interested in, young man conservatorship, no draft restriction, and the standard possession order. Besides Miss Mercado's request to change that, it doesn't seem like there's any issues with how things are going. So, state's gonna have to finalize that as is. State understands there hasn't been any family violence issues between, unfortunately. So state asks the court to keep that no non-disclosure. State asks the court to handle court costs. And I think that's it, Your Honor.
All right. All right, folks. Again, I know what y'all all request. I know what you're looking at, but again, this is kind of cut and dry based on what the law is. I'm looking at name. The law says I'm supposed to name you both joint managing conservators under most circumstances. These are the circumstances that finding should cover. So I'm going to go ahead and find that you're both named joint managing conservators of this child. I'm giving mom the right to decide domicile. That right's unrestricted. I'm going to go ahead and order guideline child support is calculated by the state. That's the new amount starts the first day of May 2026. I'm going to go ahead and order the standard possession order. Obviously, that's in full force and effect. And of course, the notice requirements and all that are, as per the standard possession order, are in there. I'm going to go ahead and find that the child in this matter is going to be 13 in December this year, correct? Is that correct, Ms. Mercado?
Yes, sir.
So I am going to go ahead and order retroactive child support based on the state's calculations for the prior 4 years of the before the temporary child support started in February, and order repayment as requested by the state on that amount. Again, this is what I would order 99%, well, 90% of the time, no matter what, unless there was some special circumstances, and I hadn't heard any special circumstances that would change this around. I'll go ahead and I'll waive court costs on this one, Mr. Welch. Again, it's a 23K is a big amount, so and it's going to take a while to pay it off. But the child, like I say, will be 18 in 6 years, and hopefully graduate on time. So that's only child support for that amount of time, sir, and the 4 years back. So there's no child support for the 8 years prior to that. The court makes a finding that there's no reason to go beyond the 4-year statute based on these current circumstances, and the law does not allow me to do anything differently than that. I'll go ahead and sign, and I'll go ahead and sign off on this order once presented. Is there anything else specifically you need me to rule on, Mr. Welch, and then I'll go to each individual party?
Your Honor, and you're confirming the new cash medical amount
starting new cash medical amount, and going forward also that's changed. I will also approve that based on the confirmation of his new salary.
And the repayment for the retro, Your Honor, 166. Are you confirming that?
Okay, it was 166. I thought it was 200 something.
No, Your Honor. The total amount is 23,130.
Right.
The repayment is 166.
All right, I'll approve that. Obviously, it's not going to go down after she turns 18 substantially, but but the court will go ahead and set that judgment amount up in order to repayment. Thank you.
And then finally, Your Honor, you're continuing the no non-disclosure we did last time.
Yeah, that's okay. The no non-disclosure, the negative, double negative is a positive in the mathematics I took, Mr. Welch, but there's no non-disclosure, right?
Yep.
Going forward. Thank you.
And I think that's about it from me.
All right then. Ms. Mercado, any questions, ma'am?
I do have a question, just so
Yes,
I
ma'am.
have it correct. So the 433 is the new amount, and then I minus the 104 from that, right?
I'm sorry, ma'am.
The 104 for the medical is going to go to the state?
Is the child on Medicaid or your private health insurance?
She's on state Medicaid.
Okay, I'll go to the state. Yes, ma'am.
Okay, so the 433 minus the 104 would put us at 330.
No. What? They're two separate amounts, ma'am. He has to pay you child support, and he has to pay the state the cash medical, or he has to get health insurance for the child. Yes, ma'am.
Okay, so then it would be the 433 plus that 166
Yes,
monthly.
ma'am. That would be the total
Okay,
amount.
I do have a question because he didn't make his payment in March, and now here we are in April. So what do we do about that?
You need to talk to the state or your own private counsel about that, ma'am, and they'll give you advice on what you want to do. But I will tell Mr. Harris, this place is called Child Support Court for a reason. And next Wednesday, I have a court date where I listen to people. You heard my morning speech. If you don't pay your child support on time, child support due the first day of the month. If you do not pay it by the last day of the month at midnight, you're in violation of the court order. And after that, after hearing on that violation, sir, I have the right to order anybody into the appropriate county jail for up to 180 days. And it's always 180 days for failure to pay child support. So you need. That was the question I was going to ask. Are you an independent contractor, sir, or are you employed by someone?
I work for someone, but
Okay.
I was under impression that it was April 6th, like I told them when they asked me. I don't know.
So it's due the first day of the month, but it's not late to the last day of the month. Okay. So the March payment, if you didn't pay it, then it's late because it's past March 31st at midnight. The April payment is not late. I'm sorry, it's late, but it's not enforceable. Throw you in jail late until the 30th at midnight.
Okay.
And I would have to hire counsel, or I call the Attorney General's office and
That's left up to
report.
you, ma'am. The child support office does enforcement cause of actions, ma'am.
Okay.
All right. Any other questions, ma'am?
I think that was it. I think I covered everything that I had questions about. Yes, sir.
All right. Thank you very much. Mr. Harris, do you have any questions, sir?
No.
All right. Anything else, Mr. Welch?
No, Your Honor. I think since this is the last case of the day, I don't think there's any more hearings or any customers. They're fine to leave, but I would like them to stay in Brickhouse just so I can confirm their contact information.
All right, folks. The state's going to put you back in the breakout room so they can confirm your email address and your phone number. The state will send you a copy of the order for your approval by DocuSign through your email address. Sign off on it doesn't mean you agree to it. Sign off on it only means that this is what the court ordered. And if you don't sign off on it, the original will be sent to the court, and I will sign off on it, and it will become the order of the court no matter what. So again, the signing off on it does mean not that you're in agreement, but this is your understanding, and after reading it, this appears to be what was ordered in this matter. So that's all that is. But so the state's gonna put you back in breakout and confirm your contact information, and after that, y'all gonna be free to go. All right?
Yes, sir.
Yes, sir.
All right. Thank you both very much. Good luck to both of you. Anything else, Mr. Welch?
No, Your Honor.
All right, we're off the record, and you can proceed by getting confirming their information, sir.